Okay, we're going to move on now to Sally. So Sally Wainwright is WDI rep for Scotland. She is the co-editor of Women's Rights Gender Wrongs. She is an expert on this issue. She spoke to us before about the significance of the issue, and I mean, it's just thank you so much, Sally, for everything you've done and for winning. So without further jubilation, I'm just going to hand over to you and hear what you have to say about it. So over to you, Sally.
As I'm sure everybody knows already, the case was intended to decide what the definition of sex was in the Equality Act. The specific question was whether men with a gender recognition certificate, that's those who've legally changed their certificated sex, should be considered women for the purposes of the Equality Act 2010. There's only about 9,000 people in the country who have gender recognition certificates, but the ruling itself has a much wider practical application because it clarifies a lot of issues relating to people who self-ID as well. And it had already been established that people who self-ID, or men in this case, who self-ID are not considered women for the Equality Act. So technically they weren't part of this discussion. And the Act gives protection against discrimination and harassment for various protected characteristics. And the protected characteristics, there's 9 altogether, but the ones that are relevant for us today are sex, sexual orientation, gender reassignment, and pregnancy and maternity. And gender reassignment, if you're not familiar with it, is a very British thing, but it sort of means self-ID. So you self-ID, but you don't legally get any change, but you socially self-ID. The Act does allow for some discrimination. So, for example, we can discriminate against men in women-only spaces, and that's how we get women-only space. So the question was, as I say, does GRC change a person's sex in the Equality Act? And the role of the judges was not to decide what's right and wrong. The role of the judges was to what's called statutory interpretation. It was a case where they were being asked to decide what the law actually already says. And if it's unclear, they can examine the context of the legislation and look at the meanings of the legislation, the things within the legislation to see what they think was intended. A bit of a spoiler alert, but I think you already will know the answer, which is that the terms woman, man, and sex were found to be biological, which is obviously very, very important for women. And the terminology that was used was biological sex, referring to sex at birth, and certificated sex, referring to sex attained through the acquisition of a gender recognition certificate. And the judges used that language throughout the ruling. It's a long and closely argued document. It runs to 88 pages, and obviously it's very limited what I can do in just a short time here. What I'm going to try and do is focus on the reasoning that the judges used in making their decision, because I think that might be most helpful, particularly to people who might be trying to have similar arguments in other countries. But there's an awful lot that obviously inevitably is going to get left out. So what the judges did was they went through the Equality Act line by line virtually, and they discussed them in the ruling. And I recommend reading the ruling. It's very easy to read, and it's very, very interesting. So one of the things that's interesting is that some key themes run throughout the judgment. And I think that these are really important sort of general principles for people to consider. So the first is that words should normally be given their ordinary meaning. So in other words, unless there's a reason to think that woman doesn't mean what we all understand the word woman to mean, then it means what we understand it to mean. And also they must have a constant and predictable meaning throughout a piece of legislation. So you can't use woman to mean one thing on one page of the of the Act and to mean something different on a different page of the Act. And that was important because the Scottish government was arguing that sex should be interpreted as being certificated, except in rare cases where it obviously, because of the context, needed to be treated as biological, for example, in the context of forensic medical examinations, because there was a piece of legislation where sex or gender had been central to the argument, or, for example, in the case of pregnancy and maternity, it should be taken to be biological. And the judges said you really can't have both. It's got to mean one word has to mean one thing all the way throughout. And there's an entire section on the importance of clarity and consistency. It must be possible for service providers to identify who is a member of which group. So if you have a group of people that are called men and a group of people that are called women, you have to immediately be able to know when you meet somebody or when you're talking to somebody, which of those two groups they fall into. Actually, I think it's quite funny, really, because when the GRA, the Gender Recognition Act, was drafted, the people who drafted it wanted the possession of a gender recognition certificate to be kept secret. I think they thought that we wouldn't know that a man was a man if we didn't see his gender recognition certificate and would mistake him for a woman. But the result of that, and the judges have made very good use of this provision, in my opinion, the result of that is that service providers aren't allowed to ask to see a gender recognition certificate. Well, technically, I think they're allowed to ask, but they're not allowed to do anything with the information. So it kind of comes to the same thing. So in practice, that meant that because you can't ask to see a gender recognition certificate, you have to assume that any man that rocks up and says that he's a woman is, because you mustn't discriminate in case he's got a GRC. So in practice, that provision has been used in a way to say, well, the problem with GRCs being secret is that it extends any rights that a GRC holder might have to everybody who self-IDs. Again, with these general themes, some of the points that the judges made in many different ways were that using the notion of certificated sex would cut across the definitions of woman and man and the PC of sex, the protected characteristic of sex, in an incoherent way. And this word incoherence really useful and important, because I was talking to some lawyers immediately after the judgment, and they said, oh, coherence has been introduced as a new sort of legal test for legislation, because it comes up time and time again. If you interpret things, if you interpret sex in the Act according to them to mean certificated sex rather than biological sex, that makes a lot of the provisions of the Act incoherent, and they were very concerned about coherence. So that's very useful. And the other thing that they were concerned about was that using certificated sex would lead to heterogeneous, in other words, mixed sex groups, rather than distinct groups with a shared biology, which they said led to shared disadvantage and discrimination. In other words, what that means is that if you use certificated sex, the category of women means biological women who don't have a gender record, but excludes biological women with a GRC. So it includes some biological women, it excludes some biological women, and it includes biological men with a GRC. So you've got this group that's just a mishmash of people, and there's no way of knowing whether somebody's going to be in the group of people described as women or not. And the judges didn't think that that was very helpful, I think one could say. So one of the issues that they looked at was the question of pregnancy and maternity, because there's a lot of provision in the Equality Act and indeed elsewhere that relates to pregnancy and maternity. Some of them are very complex, and they're long and complex, and I'm not going to go into them just now. Mostly they refer to employment rights, but all of them talk about women. They use the word women, and they use, I hate to say this, she, her pronouns. I mean, they use female pronouns throughout. So, you know, a woman, or the employer has to speak to her, or whatever, so that it's always about women, and only biological women can be pregnant as a matter of biological fact. I mean, there's no prospect of a biological male becoming pregnant. So that was also seen as important. And what they said was that if you use certificated sex, then women with a GRC would become legally men. So a woman who was pregnant but had a GRC would be a man who was pregnant, and he would then not have any pregnancy or maternity rights, because they're all written only for women. And the Scottish government acknowledged that and had to stand up in open court and say that that was the situation. And the judges said that it's difficult to see any good reason for such an approach, which is very much echoed what they'd said about the notion of heterogeneous groups. They'd said that they saw no good reason why Parliament should have intended sex-based rights and protections to apply to complex heterogeneous groupings and so on. So a lot of this time they're looking at what could this possibly have been what Parliament meant? No, it can't, because there's no good reason why they would have done this. Allowing men to be pregnant, certificated men to be pregnant, would break the principle of words having a consistent and predictable meaning, because pregnancy and maternity provisions would become incoherent, that word incoherent again, and unworkable unless woman and man have a biological meaning. So the Scottish government had argued that you should interpret the meaning of the word according to the context in which it appears, as I was saying before. So they were saying, oh no, woman, it means a woman with a GRC is a man except when she's pregnant, and then she counts as a woman. And that just obviously is nonsensical, completely nonsensical. So the other thing that the Act looks at in this section really is the protection of women and the particular risks that women face in relation to work and training. And again, the judges argued that if you use certificated sex, it makes it impossible to identify what specific risks there are to women at work because of these heterogeneous groups. So if some biological women are in the group called men, then the specific risks which refer to women would actually also relate to some of the people in the group of people called men, because they would be women with a certificate would be men. So you couldn't then say there are certain specific risks that just apply to women, because the individuals to whom those risks would actually apply would be spread across both groups. And again, that then became completely nonsensical, really. They also looked at the question of gender reassignment. And this was very interesting because this case was sort of about whether people with the gender recognition certificate had rights that we'd already established didn't apply to people who self-ID. All of those people in the Equality Act come within the category of people with the protected characteristic of gender reassignment. So in other words, anybody who says that they're trans has the protected characteristic of gender reassignment, whatever stage of their transitioning they are, even if it's just that they say, I think I'm going to trans, to they've had full medical and surgical interventions. All of those people have the same protected characteristic of gender reassignment. So this case was to see whether those people within that group who had a gender recognition certificate should be counted as women for the purposes of the Act, effectively for being able to come into women-only spaces and to use women-only services. And what the judges argued was that if you use certificated sex, this would create two different subgroups of people who have the protected characteristic of gender reassignment. So on the one hand, you'd have people with a GRC, and they would have greater rights than people who do not. And because the Equality Act is all written about the rights of people with the protected characteristic of gender reassignment, the judges said the Parliament couldn't have intended some small subgroup of those people to have more rights than the rest of the people with the protected characteristic of gender reassignment. They didn't think that was they didn't think that pointed to the use of certificated sex within the interpretation of the Act. Again, they came back to this issue of how would service providers know which group somebody fell into, and they make this point on several occasions, that there is nothing in the legislation that says that to have the protected characteristic of gender reassignment or to get a gender recognition certificate, you have to make any physical or physiological changes to your appearance or your body or anything. So there's no reason why people in the group with GRCs would look different from the group of people without GRCs. So you wouldn't be able to look at somebody and say, oh yes, this person falls into the category of women and this person falls into the category of men. And as I already said, you can't ask if somebody's got a GRC because that information's private. And again, they said there's no good reason. See this thing, no good reason. You have to have a good reason for doing any of these things. There's no good reason to treat people differently, depending on whether or not they possess a confidential certificate. In other words, it's what they're really saying is it's absolutely absurd to think that if somebody walks into a room, the fact that they've got a certificate that you're not allowed to see and that you can't know about should give them different rights than anybody else. It just didn't make any sense at all. And so again, they argued that this mitigates against using the concept of certificated sex. And in other words, it's better to use biological sex. And then we came to the question of lesbians. The Equality Act acknowledges 3 types of sexual orientation. That's people who are attracted to the same sex, lesbians and gay men, the opposite sex, heterosexual people, and either sex, so people who are bisexual. And the judges argue that that definition means that lesbians must be females who are sexually orientated towards other females. So they saw that female was important there. And they said that this is a coherent and understandable definition of what a lesbian is, using the biological understanding of sex. But if, on the other hand, you were to use the certificated version of sex, then this would weaken the protections given to people on the basis of their sexual orientation. Because a trans woman, which they use the word trans woman, but they go out of the way when they say trans woman to put in brackets biological male, which I love. They don't want anybody reading this to be in any doubt as to what sex a trans woman is. So a trans woman, biological male with a gender recognition certificate, who would then be legally female, but attracted to women, would become a same-sex attracted female, in other words, a lesbian. And I'm really pleased that they understood this argument, because it was one that the Scottish court had failed to understand and that we'd made very strongly. It was a very important part of the lesbian submission to the court, and they really took it on board and understood it. And they said that if you were to use that certificated sex understanding of what a lesbian was, in other words, that it would include men who were attracted to women, then it would mean that the concept of sexual orientation to members of a particular sex would become meaningless. And that was their term, it would become meaningless. And they were also concerned that this would have particular practical implications, for example, for lesbian clubs and associations, which again was an important part of our submission, you know, whether or not we had the right to meet on our own without having to let in biological men. The Scottish government, faced with this dilemma, because they kind of knew that they sort of couldn't say no, lesbians can't meet on their own, really. They came up with 3 solutions, and I put solutions in inverted commas because they're quite laughable, really. And the judgment was absolutely scathing about all of the Scottish government's so-called solutions. So one was that lesbians could meet just on our own without having men there, if we only had small associations, because associations of less than 25 people aren't subject to the provisions of the Act. So in other words, if 24 of us formed an organisation, we could get together, and if another 24 people formed an organisation, they could get together. But if we joined forces and became 48 people, then we would have to admit men. And the judgment says that this suggestion is not only impractical, but also unprincipled, which I think is quite a strong sort of slap on the wrist for the Scottish government. And then in court, the barrister for the Scottish government said, well, it wouldn't matter if we let in men with a gender recognition certificate to our associations, because, you know, lesbians aren't attracted to every other lesbian that they ever meet. And so, you know, I, for example, wouldn't have to be attracted to this particular man who'd come into my she didn't call him a man, this particular male with a GRC who'd come into my lesbian association. And so that wasn't going to be a problem. She didn't seem to understand the notion at all, or the Scottish government didn't seem to understand at all the notion of the importance of lesbian only or female only space. And again, the judges said this wasn't a solution, because whether or not we were attracted to a particular individual didn't in any way diminish the protections that we're entitled to as lesbians. And the third solution that the Scottish government's barrister came up with was to suggest that because believing in the immutability of sex is now a protected belief, as you'll know from the Maya Forstater case, that it would be possible for us to restrict membership of our lesbian associations to people, to lesbians who hold that protected belief. So as long as you were a kind of GC lesbian, you could be in a lesbian club of any size you wanted. But if you weren't a GC lesbian, then you couldn't be. And the judgment says that this demonstrates the incoherence of the Scottish government position. So basically, when they're looking at the situation for lesbians, you've got the government saying that they're unprincipled, impractical, and incoherent, which I think is pretty strong. And as an aside, I'm not sure, but I might have been the only person in the courtroom last week or week before when the judgment came out. I was in the courtroom along with a lot of other women, obviously, including some of the other lesbian interveners and our barristers. But I think I might have been almost the only person, or one of the few people in the courtroom who went in strongly believing that we were going to win, because I was so convinced of the centrality of the lesbian argument that I don't think everybody understood. I don't think everybody understands, even now the judgment's out, that it would have been, in my opinion, I'm not a lawyer, but I have said this before, that it would have been impossible, in my opinion, for the judges to find that certificated sex was the right interpretation to use in the Equality Act. Because if they'd done that, they would have had to square that with the notion that men could become lesbians by the acquisition of a single piece of paper, which anyway, we're not allowed to see. And that was so absurd and so kind of beyond the pale that I never thought that the judges were going to be able to find that way. I mean, there are obviously a lot of other reasons in favour of the For Women in Scotland position as well. But I always thought that, and in fact, quite a few people have said, you know, that they agree that the lesbian question kind of solidified it, if you like, pushed it over the line. I think there's a phrase that somebody used, because it would have been impossible. Lesbians and lesbian clubs and probably pregnant men as well. There's absolutely no way, in my opinion, that the judges could have found against those two groups. So in short, the judges said, and I'm just going to read what they actually said, that using certificated sex means that all these provisions that I've been talking about, and I quote now, which refer to sex, man or woman, are not capable of being read fairly and consistently without defeating their purpose and meaning. The protected characteristic of sex, which is at the heart of this case, is not capable of being interpreted as certificated sex. Rather, sex has its biological meaning throughout this legislation. So that really was in a nutshell how they summed up their thinking and their reasoning, because you could not come up with a coherent, consistent, fair, meaningful argument if you went any other which way. After that, they also looked at a few other provisions. So single-sex services are allowed as an exception from the, as I think I mentioned, from the sex discrimination provisions of the Act. You can discriminate against men and tell them that they can't come in to our spaces. Again, we have the problem of how do you identify who's in which group if you use certificated sex? And also that it would be impossible to establish the conditions necessary for separate sex services. Because if you say, in order to be able to have women-only services, you have to be able to justify the need for them to be women-only. But if you had to let in some men and exclude some women, then that didn't make any sense. You could never demonstrate that you'd met the conditions, because you wouldn't be it would just be incoherent again. And so the judges said the legislature must have intended to allow the exclusion of those with the protected characteristic of gender reassignment, regardless of the position of a gender recognition certificate, in order to maintain the provision of single or separate services for men and women as distinct groups. So again, coming back to these same principles over and over again, you have to be able to identify who is and who isn't in a distinct group, because otherwise you can't coherently justify anything at all. You couldn't coherently justify the need for single sex provision if members of that sex include members of the other biological sex. And the example they gave was a cervical cancer screening service, which obviously only applies to biological women. And so therefore is a women-only service, except that if you start saying that people have certificated sex instead of biological sex, then it's no longer a single-sex service, because some people who would legally be counted as men would still need the service. So they would either be excluded from it, or it would no longer be single-sex. So either which way, you're in a mess. So moving on a bit, the judgment also looked at situations where men can be excluded. I think this probably works the other way around as well, but I'm just going to talk about excluding men, where men can be excluded because women might have a reasonable objection to the presence of a person of the opposite sex. Some of the examples of those places are changing rooms, hospital wards, or rape crisis services. So, you know, those of you who've been following the Sandy Peggy case, for example, and the Darlington nurses, who know that in both cases, nurses have been expected to change in a room with male doctors who claim to be women, that this section applies directly in those cases, which is probably why Fife NHS has gone away saying, oh, we're going to study the judgment very closely, because it really makes a nonsense of their argument. And what they said is it's impossible to make a reasonable objection in practice if you use certificated sex, because the whole thing just becomes a mess again. When would it be reasonable to object to the presence of a man who self-IDs, but not object to the presence of that same man if he then goes away and acquires a gender recognition certificate? You know, what is it that would make your objection somehow go from being reasonable to not reasonable? That doesn't make any sense. How would the woman objecting to the man's presence know whether or not he had a gender recognition certificate? Because we've got all the same problems as before. And now there's a very important point that I think it was the end of a very long paragraph, and I think quite a lot of people are only starting to catch up with now, that the judgment also said that you can make a reasonable objection to the presence of biological women living in the male gender where they have had probably surgery or hormonal or medical interventions anyway. That's not a condition, but that's probably the reason, which gives them a very strong masculinized appearance. So in other words, if a woman walks in, if a person comes into your changing room, you know, and they're bearded and, you know, male pattern baldness and all the rest of it, you can throw them out, and they can't say, oh, but I'm really a woman, I'm a woman on testosterone, because that would be impossible to prove. I mean, this isn't the reasoning they gave, but that's what they said, you could reasonably object to that person being there. And I think it's really, really important, because without it, and I don't know if this is why the judges put it in, or whether it was just because they were being very, very thorough in their explanation of the legislation, but it means that without this provision, any man could have walked in and claimed to be a trans man, in other words, a biological woman, and it would have been very difficult for us to insist he leaves. So this, I think, is really important. I have to acknowledge it might also, for some people in that situation, present them with some difficulties, but that's going to have to be resolved at some point. A whole range of other single sex things are covered where there might be reasonable objections, situations where there might be physical contact, for example, like a massage service, communal accommodation, higher education, breastfeeding charities, and also they covered fair participation in gender-affected sports. But again, I don't really have time to go into that. One thing that was very important was that they also talked about the collection of data. And they said that using certificated sex would mean that you are collecting data again on heterogeneous groups rather than distinct groups, and that this is confusing this group of people that includes some women but not all of them, and some men, and that the data collection will be distorted, and that the distinct discrimination and disadvantage faced by biological women cannot be addressed if you collect data in this very guddly way. So the rights of people with the protected characteristic of gender reassignment is obviously been causing an enormous amount of upset, and there's been violent protests. And, you know, I've had friends from the States writing and saying, oh, I'm really worried what's happening, you know, with all this violence and stuff. And of course, there's been an enormous amount of confusion and misinformation. So it's important to say that the ruling does not take away any rights from anybody that they already had. I think the difficulty is that for many years, people have been being told by Stonewall, by the Scottish Trans Alliance, by, you know, a whole load of other trans charities, that they have the right of access to wrong spaces if they self-ID as trans, never mind if they've got a gender recognition certificate. So loads and loads of people genuinely believe themselves to have this right. And what's a real shock to them is that the Supreme Court has now come out and said, no, you don't have this right. Actually, you've never had it. However, you do have a lot of rights under the Act. And people who self-ID, or people with, well, everybody with a protected characteristic of gender reassignment, may have lost the delusion that they are can behave as if they were the opposite sex. But the ruling clarified that sex and gender separately rather than joined together, which is what had been happening, that there'd been this, basically the movement had been trying to merge the characteristic of gender reassignment with the characteristic of sex. And this ruling clarifies absolutely clearly that they are to be protected separately, that both groups. Under the Equality Act, people with the protected characteristic of gender reassignment have 3 different types of protections. They're protected on the basis of their sex, they're protected on the basis of their sexual orientation, and they're also protected on the basis of their gender reassignment. In other words, if somebody who's got the protected characteristic of gender reassignment is discriminated against because they're an actual woman, even though they, you know, try and present as a man, then that's sex discrimination. If somebody doesn't give them a job because they think they're a lesbian, then that's discrimination on the basis of their sexual orientation. And if somebody doesn't give them a job simply because they don't like the fact that they present as the wrong sex, and there's no other reason, then that would be discrimination on the basis of gender reassignment. So they have all those protections. And the other thing that's interesting and has always been part of the Equality Act, but really doesn't happen very often, but might happen in the case of some of these individuals, is that they have the right not to be discriminated against on the basis of perception. So in other words, if I'm heterosexual and you think I'm a lesbian and you're wrong and you don't give me a job because you've perceived me to be a lesbian and you don't give me a job for that reason, or you don't let me into your club, or whatever, however you discriminate against me, then I have a claim against you on the basis of sexual orientation. The fact is that you have discriminated against me for being a lesbian, even though I'm not a lesbian. Well, I am, but, you know, in this scenario, even though I'm not a lesbian, you've discriminated against me. So this is the same here. If a trans identifying male went for, I'm going to keep using the job interview examples, but it applies in anything else. If he went for a job and a self-IDing person, and he was perceived to be a woman, which he's not, and he wasn't given the job because he's a woman, because he was perceived to be a woman, he would have a claim for sex discrimination. So there's a very, very wide range of protections available to everybody. generally speaking, the outcome's very good for women, but there's still an awful lot to do, because self-ID is deeply entrenched in many parts of UK society. And although the rulings are a really good basis to argue against it, we're not going to get rid of self-ID anytime soon. There's been this massive spread of disinformation by trans organizations, which is going to be really hard to overcome. And they're now telling vulnerable young people, oh, the UK is no longer a safe place for you to live, and the rule is incompatible with the human rights legislation, and that men still have the right to use women's toilets, none of which is correct, but is causing a great deal of fear and alarm. But the biggest one for me is what I've taken to calling Schrodinger's sex. I should have put a copyright mark after that, by the way, because the ruling doesn't undo the certificated sex that somebody has acquired through a gender recognition certificate. So males with a gender recognition certificate are male for the purposes of the Equality Act, because that's what we've just been talking about. But that doesn't apply to other laws. And in particular, the one that's been causing a lot of concern recently is about the fact that it might not refer to all situations where people are being strip searched. So there's a particular concern that a man who claims to be a woman can demand to be searched by another woman, or a woman PC, and that woman might then find herself in a difficult situation. But also, and this is old news, that they're still effectively regarded as men within the terms of the gender recognition certificate, because the GRA, the Gender Recognition Act itself, excluded the terms of the change of sex provisions within when you've got a GRA from applying in certain cases where if you came to inherit property or peerages, your status as a mother or a father isn't affected, as we saw in the Freddie O'Connell case, and participation in gender-affected sports. So in other words, these people have both sexes all at the same time, which are as recognised by the government, which I think is absolutely ridiculous. I've used gender here because that's the language used in legislation. It should say sex, of course. And in my opinion, more than anything, what this shows is the absolute importance of us getting rid of the Gender Recognition Act and all forms of sex falsification, because this is exactly the sort of mess that you get into otherwise.
Any comment on the EHRC saying that services don't need to have single-sex facilities, but can have all mixed sex? And what about women who identify as men being banned from women's toilets? How would that work?
Well, I think I mentioned the women who identify as men being banned from women's toilets in the sense that if they, present as men and they're taken to look, everybody thinks that they're men, then they can be banned from single-sex services. I think there is a real problem. One of the things that I've been really worried about is that in many cases where it's possible, service providers are going to go, oh, this is all just too complicated, I can't be dealing with it, let's just make everything mixed. So they'll make all their toilets or changing rooms or whatever mixed within the terms of the law. Now, there are some places in UK legislation, so the workplace regulations and the laws around schools require the provision of single-sex toilets and changing rooms. So in workplaces, as a member of staff, let's say I was talking to a friend who runs a pub about this the other day. I was saying that, so the law says that you as a member of staff in the pub are entitled to a single-sex toilet, but me as a customer, I'm not entitled to a single-sex toilet, because automatically entitled, because the big issue within the Equality Act is that it's largely permissive when it comes to single-sex provision. It's not mandatory. And so I think there's a real danger, and there'll be a big push from the trans lobby about this, that as many facilities as possible will be turned into being mixed. Now, in some places, that's obviously not possible. I mean, you're not going to be able to do that in terms of sports, for example. But even hospital wards, there are such things as mixed hospital wards already. They've always existed. I wouldn't be surprised if we don't see them pushing to have mixed wards so that anybody can be anywhere they want. So I think it's a very good question. It's a very big problem, and I think I think there's going to be a lot more court cases. I think this is the beginning of the battle, very much nowhere near the end of it. I mean, although we're seen to have been, you know, obviously we're delighted, because without this we wouldn't even be at the starting point. But with this ruling, that there's still an enormous amount of work to be done to roll back the nonsense that's occurred over the last 15, 20 years.